Good afternoon. I hereby call to order this second meeting of the Pennsylvania Public Utility Commission for the year 2018 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. For those of you that are joining us today for our public meeting, I want you to take note of the exits down the stairs on either side of this hallway are exits which you can go to outside to the North Street. If there were a true emergency, there would be a PUC employee that will be outside with the orange vest on that could help those that will need assistance. Once you have moved down the stairs, please exit onto North Street, as I stated. And for your convenience, our restrooms are located across the atrium near the cafeteria, and that's the Forester Street side of the building. Before we move on, as everyone can see, I'm wearing my green, closest I can get to Kelly Green, and this is all for FERC Commissioner Rob Powelson. I know he would be proud of me. We have some very strong Steeler fans sitting here on this bench, but we want to take the time to acknowledge the Philadelphia Eagles on their win of the Super Bowl last Sunday. And I know there's many of you that are probably or were probably watching the parade that is taking place right now. But we, as the Pennsylvania Public Utility Commission, do want to take this opportunity to acknowledge and congratulate the Philadelphia Eagles.
Well said.
They forgot to get the script. Moving on to our agenda, I would like to recognize Commissioner Sweet, who is the editor of the minutes for December 21st, 2017.
Madam Chair, I've reviewed the minutes of the public meeting December 21st, 2017, and move they be approved as submitted.
Thank you very much. You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion, edits of the minutes? Hearing none. All those in favor of approving the minutes from December 21st, 2017, please say aye.
Aye.
Any opposed? The motion passes 5-0. Moving on to our agenda, we do have back with us Cheryl Walker Davis, our Director of Office of Special Assistance. I did my best that I could last December, having a cold at the same time, but we got through it, so we welcome you back.
Thank you, Madam Chairman. I understand you did an excellent job.
I coughed my way through the whole thing.
May it please the Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Commission's Bureau of Audits. That's on page 1 of the public meeting agenda. The first matter there appearing is Pike County Light and Power Company and Leatherstocking Gas Company, LLC, and the matter pertaining to the release of the audit report and implementation plan associated with the Focus Management Operations audit.
Is there a motion to call up this matter for consideration?
So moved. Second.
We have a motion by Commissioner Kennard, second by Commissioner Sweet. Under discussion, is there any discussion?
Yes, I have a
Vice
motion.
Chairman Place.
Thank you. Madam Secretary, I request that my motion be placed into the record as if I read it in its entirety. Before the Commission is the Focus Management and Operations Audit of Pike County Light and Power Company and Leatherstocking Gas Company, and the company's implementation plan dated December 28, 2017. Audit staff rated 9 functional areas or specific issues that were examined during the audit and identified 33 recommendations for improvement. A number of these recommendations are related to Pike's divestiture from Orange and Rockland Utilities Incorporated and acquisition by Corning Natural Gas Holding Corporation on August 31, 2016. Corning had previously entered into a joint partnership with Mirabito Regulated Industries, LLC, to form Leatherstocking, which was subsequently certified by the Commission on September 27, 2012. Despite operating Leatherstocking in Pennsylvania for 4 years, the acquisition of Pike substantially increased Corning's operations and regulatory requirements within Pennsylvania and expanded Corning's activity into electric utility operations. As the audit was conducted shortly after Pike's acquisition, the audit team had difficulty acquiring certain data or information on specific procedures. In some cases, Pike had not implemented or completed IT systems such as an outage management system, customer service information system, or work management system. Taking the transition into consideration, the audit team focused its efforts on identifying key procedures or processes lacking at Pike. Due to the importance of ensuring that Pike's management effectively implements the audit recommendations and establishes proper systems and controls, it is vital that Pike provide the Commission with additional progress updates. As a result of the management audit, Pike is already required to file progress reports on all audit recommendations by February 1st for the next 3 years. In addition, Pike is to continue to provide quarterly updates pursuant to the settlement agreement related to the sale of Pike to Corning to various parties, including the Commission. However, given the gravity of some of the identified audit deficiencies, the Commission will impose the following additional reporting requirements. The Commission directs Pike to file a status report with the Bureaus of Technical Utility Services, Investigation Enforcement, and Audits by July 1, 2018, and add the below requested information to the existing implementation progress report due by February 1, 2019. Each status report shall provide updated information regarding Pike's implementation of the accepted audit recommendations with a focus on the following. Expand safety manual to include detailed safety topics related to gas and electric operations. Update Pike's storm response and restoration plan and tailor it to Pike's available equipment, resources, and capabilities. Develop 4 required plans: emergency response, physical security, business continuity, and cybersecurity plans. Select, purchase, install, and test in a timely manner all required IT systems required to run and manage Pike. The report should include a status report on computer systems, including the outage management system, work management system, SCADA system, and the interface between systems. Develop and periodically update an electric operations and maintenance manual specific to Pike's system. The Commission further directs Pike to file a status report with the Commission's TUS Reliability and Emergency Preparedness section, I&E, audits, and the statutory advocates on April 1, 2018 regarding Pike's completed plan and cost-benefit analysis required by the acceptance of the management audit recommendation. This item requests that Pike develop a staffing plan to document the cost-benefit analysis used to support the decision-making process in determining staffing levels resources. In addition, Pike is directed to hold a meeting during the 4th quarter of 2018 with staff from TUS and audits to review the completed plans required by the management audit recommendations. Further, Pike is directed to file a written monthly status report to the Commission's Office of Competitive Market Oversight on their electronic data interchange capabilities and when they expect to have EDI fully available for electric generation suppliers. At the same time, ACMO is encouraged to continue its monitoring and coordination with Pike and EGSs to ensure that Pike's customers receive the benefits of electric competition in accordance with the Commission's regulations. Pike is also reminded to timely file all of its required regulatory reports as prescribed by the Commission. Therefore, I move that 1. The Commission make the focused management and operations audit report and the company's implementation plan public. 2, the Commission issue a secretarial letter directing the companies to proceed with their implementation plan and submit progress reports on the implementation plan annually by February 1st for the next 3 years. 3, Pike County Light and Power Company and Leatherstocking Gas Company are directed to file the status reports at the times prescribed as identified in this motion. 4, Pike is directed to hold a meeting during the 4th quarter of 2018 with staff from TUS and audits to review the completed plans required by the management audit recommendations. 5, the Office of Special Assistants prepare an opinion and order consistent with this motion. And finally, 6, the docket remain open for the filing of the required reports described herein with the Secretary of the Commission. Thank you.
Thank you, Vice Chairman Place. You have heard the motion. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, is there any objection to taking the previous roll call? No. Saying none, the matter as amended by Vice Chairman Place's motion passes 5-0.
Madam Chairman and Commissioners, the next matter appearing on page 2 of the public meeting agenda pertains to the joint petition of Duquesne Light Company as well as the Coalition for Affordable Utility Services and Energy Efficiency in PA and the OCA with regard to the Customer Assistance Program. There is also the petition for approval of a new CAP bill design and customer communication plan.
Is there a motion to adopt staff recommendation?
So moved.
Second.
Moved by Vice Chairman Place, second by Commissioner Coleman. Any discussion?
Second joint
Vice
statement.
Chairman Place.
Thank you very much. This is a joint statement with Commissioner Sweet. Madam Secretary, I would ask that our statement be placed into the record as if it had been read in its entirety. Before the Commission for consideration is the draft order regarding, in part, the joint petition of Duquesne Light Company, the Coalition for Affordable Utility Services and Energy Efficiency in PA, and the Office of Consumer Advocate seeking to further amend Duquesne's 2017-2019 Universal Service and Energy Conservation Plan. The petition requests a modification to Duquesne's existing customer assistance program and requests a waiver of the Commission regulations to allow its amended proposal plan to be effective through 2022. The order before us grants the petition in part, allowing for certain consensus changes to Duquesne's current customer assistance program, and denies it in part, requiring Duquesne to file a 2020-2022 Universal Service and Energy Conservation Plan by or before February 28, 2019. In March 2017, Duquesne came before the Commission with a revised version of its Universal Service and Energy Conservation Plan for the period 2017 through 2019. At that juncture, we introduced a motion which ordered that Duquesne, among other items, begin a collaborative to address design issues in its customer assistance program. The joint petition before us today is a result of that collaborative effort. Before addressing the issues at hand, we want to applaud Duquesne, CAUS PA, and the OCA for this successful collaboration. These are complex topics with real impacts for Pennsylvania households, and we are impressed with the petition before us today and the consensus upon which this petition and its contents stand. The interim approach of increasing the ceiling for CAP credits, thereby reducing consumer bills, is a good step forward to achieving affordability for Pennsylvania's low-income and fixed-income residents. However, Duquesne also proposes a second phase of CAP changes in which they would transition from a percent of bill program to a percent of income program in 2020, with an associated waiver of Commission regulations affording a 3-year extension of their current USECP until 2022. It is this portion of the petition that the Commission denies. Nevertheless, this partial denial should not be viewed as a reflection on the merits of the petition and collaboration as a whole. With the open dockets regarding universal service and energy affordability, the Commission is exploring new ideas that might result in the formulation of certain requirements regarding Pennsylvania's universal service programs, which is why we believe it is premature for Duquesne to make extensive policy changes within their plan at this time. We thank Duquesne for their continued participation in these comprehensive efforts and look forward to Duquesne continuing this collaboration as they prepare for their upcoming universal service filing. Thank you.
Thank you, Vice Chairman Place, for the joint statement. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to page 3 of the public meeting agenda, on behalf of the Office of Competitive Market Oversight, it is recommended that the Commission adopt the recommendation there appearing with regard to the PPL Electric Utilities Corporation Customer Assistance Program Standard Offer Program.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
I have a conflict statement.
Commissioner Sweet.
Before joining my staff as legal counsel, Susan Colwell was working in the Office of Administrative Law Judge and worked on this case in that capacity. Please note she has not advised me on this matter.
Thank you very much. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Office of Special Assistance, commencing on page 4 of the public meeting agenda, it is recommended in omnibus fashion that the Commission adopt the recommendations appearing on page 4 with regard to 110 Associates LLC versus Duquesne Light Company, as well as Brown and A. Fisher versus PPL Electric Utilities Corporation, as well as the first recommendation appearing at the top of page 5 in the matter involving the Commission's Bureau of Investigation and Enforcement versus Charles H. Edwards, Jr.
Is there a motion to adopt the staff recommendations?
So moved.
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Any discussion? Hearing none, all those in favor say aye.
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 Any opposed? The motion passes 5-0.
The next matter is that pertaining to the application of the Keystone Transportation LLC to provide paratransit service between 38 counties in Pennsylvania and return.
Is there a motion to call up the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Discussion.
I have a motion, Madam Chair.
Commissioner Sweet.
Before the commission are the exceptions filed by Keystone Transportation LLC, excuse me, whose application for approval to provide paratransit service in 38 Pennsylvania counties was denied by the initial decision of Administrative Law Judge Elizabeth Barnes. This motion affirms the initial decision for the reasons enumerated by the ALJ, but with one important difference, that the Commission's elimination of the so-called need requirement be included in the final Commission order. The Commission eliminated the requirement that an applicant prove that approval of the application will serve a useful public purpose, responsive to a public demand or need by final rulemaking order, entered October 27th, 2016, and the regulation became final on June 3rd, 2017. The initial decision was issued before this change took effect, and the analysis was consistent with the law at that time, that is prior to June 3rd, 2017. However, our evaluation of the exceptions is occurring now, some 8 months after the regulations removed the requirement that need be evaluated, and that requirement should not be applied here. This is not a retroactive application of law. Retroactive laws are defined as those which take away or impair vested rights acquired under existing laws, create new obligations, impose a new duty, or attach a new disability in respect to the transaction or consideration already passed. A substantive right is implicated when the retroactive application of a statute imposes new legal burdens on past transactions. Here, the Commission has not imposed a new burden, but has reduced the burden on any applicant seeking authority to provide motor carrier service in the Commonwealth by eliminating what had been used as an entry barrier. Our approach today is consistent with a line of cases finding it is appropriate to apply the law in effect at the time of the decision rendered. These include cases where the courts apply intervening statutes that confer or remove jurisdiction. In fact, it would be an elevation of process over substance to apply a need requirement, as was done here, to any case pending before us, as any applicant refused authority based on its failure to meet the requirement that will not apply to applications filed after June 3rd, 2017, could simply refile the same application now and get a different result. That defies both logic, I would assert the law, and common sense. The initial decision here denies the application based on the applicant's failure to demonstrate it possesses the technical and financial ability to provide the proposed paratransit service. And the exceptions to these findings are denied for the reasons set forth in the initial decision. The exception based on the initial decision's finding that the applicant had failed to demonstrate that the approval of its application would serve a useful public purpose, responsive to a public demand or need, is granted, as that issue is now moot, based upon applicable law today as it reads, as this tribunal meets and decides. Just parenthetically, I would say, Madam Chair, before I actually move, There's an old adage that if you're digging in the wrong place, the first thing you do is stop digging. And we have, in my mind, erroneously made decisions that included language that leads one to an improper conclusion about the need requirement. I would submit that we need to stop digging in this particular spot and, in effect, reverse what some see as a prior precedent. Therefore, I move that the exceptions of the applicant Keystone Transportation LLC are granted insofar as the failure to demonstrate that the approval of this application would serve a useful public purpose responsive to a public demand or need is now moot and are denied in all other respects, that the initial decision of Administrative Law Judge Elizabeth Barnes is affirmed as modified by this motion, and that the motion of special assistance, or the Office of Special Assistance, prepared appropriate order consistent with this motion. Thank you.
Thank you, Commissioner Sweet. You have heard the motion of Commissioner Sweet. Is there a second on the
Second.
motion? Second by Vice Chairman Place. Discussion on the motion. Commissioner Coleman.
Madam Chair, I certainly am sympathetic to my colleague's plea for the elimination of need. In fact, this is one of the initiatives that I led in coming to the commission. I also agree with him with the idea in administrative expediency. But I think there are a couple of other pieces here that we need to take into consideration. And one is regulatory certainty, and that this commission has made a decision. In fact, we have now a precedent on 3 cases in which we have voted unanimously on this matter. And so as much as I agree with Commissioner Sweet that we need to get beyond the demonstration of need for transportation carriers, I just don't think today is the day on this particular case, but I will remain open-minded as we go forward and look at other cases that may be pending before the commission.
Thank you, Commissioner Coleman. Any further discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
I will also be voting in the negative as well. The motion fails 2-3, noting the dissents of Commissioner Coleman, Commissioner Kennard, and myself. That moves us back to the original staff recommendation under this matter, Keystone Transportation LLC. Under that, any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Madam Chair, I would concur in result only.
Okay.
That's what I.
Okay. The motion passes 5-0, noting concurring in the result only of Vice Chairman Place and Commissioner Sweet.
It is recommended that the commission adopt the Office of Special Assistance recommendations in the matters commencing with that at the bottom of page 5 involving the Commission's Bureau of Investigation and Enforcement versus SFE Energy Pennsylvania, Inc., and continuing with the 2 items on page 6, Bureau of Investigation and Enforcement versus Augustus Reed Jr., TA Augustus Reed Jr. Limousine, as well as the Bureau of Investigation and Enforcement versus Maidens Taxi Service LLC. The items on page 7, which are there listed, and turning to page 8, the first 2 items through and including that matter involving the formal complaint of Jean Toma versus PPL Electric Utilities Corporation.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
The next matter before the commission is that pertaining to the formal complaint of Ifedu Inigwe versus Philadelphia Gas Works.
I am so glad you were able to pronounce that name. I was trying my best. Is there a motion to call up the staff recommendation for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard to call up this matter for consideration. Is there any discussion?
I'll have a motion, Madam Chair.
Commissioner Sweet.
And I would ask that my motion be entered into the record as if I read it in its entirety. Before the Commission for decision of the exceptions filed by Ifedu Inigwe to the initial decision of Administrative Law Judge Andrew Calvelli, which granted the customer's request for a payment arrangement but denied his allegations that Philadelphia Gas Works, PGW, had acted improperly and by doing so had prevented him from being awarded funds from a PGW hardship grant. While I agree that the evidence supports the ALJ's ruling regarding PGM's actions in this matter, the record does not reflect the information necessary to support the award of the payment arrangement. With this motion, I seek to remand the case for additional proceedings to supplement the record and to ensure that the level of payment arrangement granted is the correct one. In this case, the complainant is a taxi driver whose income fluctuates from month to month. While he explained this to the ALJ in the hearing, he did not provide evidence or documentation about his monthly income, which is its monthly household income, which is a crucial element to determining the level of a payment arrangement. The ALJ who wrote the initial decision was not the ALJ who conducted the hearing. In attempting to determine household income, the ALJ relied on the complainant's self-reported income given to BCS. Unfortunately, this information was hearsay, in that it was neither subject to cross-examination nor provided under oath. This information also was not corroborated by other record evidence. Accordingly, the findings of fact that discuss the BCS proceeding have no place in an initial decision for a timely appeal from that BCS decision. Rather, the information necessary to support an initial decision must be based on evidence of record in the formal proceeding. A reading of the transcript reveals that Mr. Inigwe, in his attempts to show the ALJ that his income fluctuated monthly, failed to provide the actual numbers on which a payment arrangement could be based. The Commission is bound by the provisions of the Public Utility Code that require the Commission to base payment arrangements on where the customer's household income falls on the federal poverty scale. And that means that we need to have the income of the customer. The case must be remanded to make clear to Mr. Inigwe that he has the burden of giving the Commission the information necessary to determine where his household's monthly income falls on the federal poverty scale so that we can apply the level of payment arrangement that is appropriate. Also, in addition to Mr. Inigwe's income, the income of any other adult household members must also be included. Determining annual household income and identifying the length of the payment arrangements can be granted. Mr. Inigwe's exception regarding the manner in which PGW handled his grants will be denied, as PGW provided an adequate explanation for its actions. Therefore, I move that the exceptions of Afidu Inigwe are denied, that the initial decision of the administrative law judge is affirmed in part and denied in part, consistent with this motion. That the matter be remanded to the Office of Administrative Law Judge for proceedings limited to establishing the appropriate length of the payment arrangement, and that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion?
Statement.
Vice Chairman Place.
Thank you very much. In this case, Mr. Inigwe filed an exception regarding the manner in which PGW interacted with the Utility and Emergency Services Fund regarding his grant application, which ultimately was denied. As part of the prerequisites to receiving his grant from UESF, Mr. Inigwe was instructed to apply for a LIHEAP grant. However, the act of applying to LIHEAP resulted in his PGW's account's termination status being lifted, therefore disqualifying him from the UESF grant, for which facing a termination was a requirement. It is concerning that Mr. Inigwe followed the steps necessary to ensure the UESF grant. These same actions then disqualified him, the proverbial catch-22. It is in the mutual interest of both parties to successfully execute these grant applications. It seems in this instance there may be a procedural issue that, with enhanced coordination between the fund and PGW, might easily be resolved. Coordination among utilities, consumers, and assistance programs is essential in helping customers manage arrearages and utilities receiving payment for services rendered. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. On the motion, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended by the motion, is there any objection to taking the previous roll call? Hearing none, all those in favor, well, hearing none, it passes 5-0 as amended.
Continuing with the presentation of agenda items, it is recommended that the commission adopt the next two items, the recommendations in the next two items appearing on page 9 pertaining to Harry Larry Byerly versus National Fuel Gas Distribution Corporation, the formal complaint in that proceeding, as well as the complaint involving Norbert Slawinski versus Duquesne Light Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
The next matter pertains to the formal complaint proceeding involving Glenn DeHaven versus Pico Energy Company.
Is there a motion to call up the staff recommendation for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Under discussion, I do have a motion, so I will turn over to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
I ask that my motion be entered into the record in its entirety, as if I read it in its entirety. Before us for consideration is the complaint filed by Glenn DeHaven against Pico. Mr. DeHaven argues that Pico should not have transferred his tenant's arrearage to him when foreign load was discovered at his rental property. This is the first time in my tenure on the commission that the issue of a landlord liability for usage not connected to the landlord's property has been expressly challenged. With regard to the $1,036.69 of usage, which the tenants accrued prior to moving into Mr. DeHaven's property, logic dictates that this is usage which is wholly unrelated to Mr. DeHaven's property, usage which was not at all affected by the electric wiring of Mr. DeHaven's property, and therefore usage for which Mr. DeHaven bears no responsibility. It should be noted that Section 1529.1 of the code states in pertinent part, in the case of individually metered dwelling units, unless notified to the contrary by the tenant or an unauthorized representative, an affected public utility shall list the amount for the premises in question in the name of the owner, and the owner shall be responsible for the payment for utility services to the premises. To hold this landlord responsible for usage which accrued at property other than the premises which he does not own is an unreasonable construction of this statute. As such, this matter should be returned to the Office of Administrative Law Judge to determine the amount of usage which accrued prior to the tenants moving into Mr. DeHaven's property. That amount should be removed from Mr. DeHaven's bill, as Section 1529.1 does not transfer responsibility for a tenant's prior outstanding balance at another premise to a new landlord at a new premise. The prior outstanding balance remains the responsibility of the tenant. The portion of the bill which accrued at Mr. DeHaven's property remains his responsibility pursuant to Section 1529.1. Therefore, I move, one, that consistent with this motion, the ALJ's initial decision be reversed in part and remanded for fact-finding regarding the amount of the tenant's arrearage not related to Mr. DeHaven's property. 2, that Mr. DeHaven is not to be billed for usage which did not occur at his premises. And 3, that the Office of Special Assistance draft an opinion and order consistent with this motion.
Thank you. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Kennard. Any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries 5-0. Gavel is yours, Chairman.
On the matter as amended, if there's no objection, we can go with the previous roll call. Seeing none, the matter as amended passes 5-0.
Turning now to page 10 of the public meeting agenda, it is recommended that the commission adopt the OSA recommendation in the first item pertaining to the petition for reconsideration involving the West Goshen Township versus Sunoco Pipeline LP.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second? will. Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
The next matter pertains to the formal complaint of Richard Dina versus Pico Energy Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Place. Under discussion, I do have a motion, so I will turn it over to Vice Chairman Place to preside.
Thank you. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
I ask that my motion be spread upon the record as if I read it in its entirety. That's why I don't say that long thing, because I'm always stumbling over it. But thank you very much. On March 2nd, 2017, Richard Dina filed a complaint alleging that PICO improperly transferred his tenant's account and arrearage to his name when foreign load was found on the tenant's meter. The complaint was dismissed on a preliminary objection. This is a case similar to the DeHaven versus PICO case, which I previously discussed, in that it also allows a landlord's liability for an arrearage accrued by tenants prior to their moving into his property. To hold this landlord responsible for usage which accrued at a property which he does not own is unreasonable. As such, this matter should be returned to the Office of Administrative Law Judge to determine the amount of usage which accrued prior to the tenants moving into Mr. Dina's property. If that amount has not been paid off by the tenants, it should be removed from Mr. Dina's bill. The portion of the balance which accrued at Mr. Dina's property remains his responsibility pursuant to Section 1529.1 of the Code. Therefore, I move that, 1, consistent with this motion, the ALJ's initial decision be reversed in part and remanded for fact-finding regarding the amount of the tenant's arrearage not related to Mr. Dina's property. 2, that Mr. Dina is not to be billed for usage which did not accrue at his premises. And 3, that the Office of Special Assistance draft an opinion and order consistent with this motion.
Having heard the motion, is there a second?
Second.
Seconded by Commissioner Kennard. Any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? The motion carries 5-0. Gavel is yours, Chairman.
Thank you. On the matter as amended by the motion, if there's no objection, we can take the previous roll call. Seeing none, the matter as amended passes 5-0.
It is recommended that the commission adopt the recommendation of the Office of Special Assistance and the remaining item at the bottom of page 10 in the matter involving the formal complaint of Jim W. Schaefer versus Columbia Gas of Pennsylvania, Inc.
Is there a motion to adopt the staff recommendation?
So moved. Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. You notice how they've all worked this out this time. There's no trying to
smooth, isn't it?
figure out who's second anything. Thank you. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Bureau of Technical Utility Services, in omnibus fashion, it is recommended that the Commission adopt the items commencing with that at the top of page 11 in the matter involving the application of Pennsylvania Turnpike with regard to the replacement of the existing bridge where the Pennsylvania Turnpike crosses the tracks of CSX Transportation, Inc. and Norfolk Southern Railway Company, and continuing throughout the remaining items on pages 11, 12, and 13 through and including the last item pertaining to the Mid-Atlantic Interstate Transmission LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to page 14 in those matters presented on behalf of the Law Bureau, it is recommended that the Commission adopt the two items appearing there, the first pertaining to the PUC versus North Heidelberg Sewer Company, and the second pertaining to the rulemaking regarding minimum requirements for motor carriers of passengers.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Office of Administrative Law Judge, we're on page 15 of the public meeting agenda. The first matter pertains to the application of the Pennsylvania Electric Company for approval to locate, construct, operate, and maintain a high-voltage transmission line, the Bedford North Central City West 115 kV HV transmission line. And before the Commission is ALJ Watson's recommended decision.
Is there a motion to call up the matter for consideration?
So moved.
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Under discussion, is there any discussion?
I have a motion on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I request that my motion be entered into the record as if I had read it in its entirety. Before the Commission is the application of Pennsylvania Electric Company for the approval of the siting and construction of the high-voltage transmission line referred to as the Bedford North Central City West 115 kV HV transmission line project, and the application to exercise the power of eminent domain to acquire a certain portion of the lands affecting numerous landowners. I support the approval of the application as recommended by the Administrative Law Judge as amended by this motion. While I support the approval of the application, a few aspects of the recommended decision require modification. In accordance with the provisions of Title 66 and the Commission's regulations regarding the siting and construction of high-voltage transmission lines, the ALJ analyzed the application in a thorough manner. However, the ALJ included case precedent references to the Payne versus Kassab test in the RD, which is no longer valid and should be stricken. The Pennsylvania Supreme Court invalidated the Payne versus Kassab test in Pennsylvania Environmental Defense Foundation versus Commonwealth of Pennsylvania in 2017. Therefore, the Commission will no longer apply the three-part test articulated in Payne versus Kassab in transmission line cases. Pennsylvania Environmental Defense Foundation addressed the contours of the trust created by Article 1, Section 27 of the Pennsylvania Constitution, which placed Pennsylvania's public natural resources in trust and named the Commonwealth as its trustee to conserve and maintain these resources for the benefit of all people, including future generations. Pennsylvania Environmental Defense Foundation replaced the three-part test articulated in Payne versus Kassab with instructions to apply the test of Article 1, Section 27 itself and the underlying principles of Pennsylvania trust law as are related to Pennsylvania's public natural resources. The Supreme Court also noted that the individual rights of citizens to clean air, pure water, and to the preservation of natural, scenic, historic, and aesthetic values of the environment may be subject to reasonable regulation. Our siting regulations are in accord with the Environmental Rights Amendment by requiring that the environmental impacts of the proposed transition siting route be minimized. Specifically, the Commission's regulations require the review of evidence regarding the necessity and safety of the proposed line, the impact on and mitigation of effects on several criteria, including land use, soil and sedimentation, plant and wildlife habitats, terrain, hydrology, landscape, scenic rivers, and archaeology, geologic, historic, scenic, and wilderness areas. In addition, the Commission considers evidence regarding reasonable alternate routes. After review of the evidence, the Commission's regulations require that no order will be issued granting an application unless it finds that there is a need for the line, that it will not create an unreasonable risk of danger to the health and safety of the public, that is in compliance with applicable law for the protection of the natural resources of this Commonwealth, and that it will have a minimal environmental impact. The Commission's regulatory scheme for high-voltage transmission siting cases therefore provides for a robust, evidence-based, deliberative process that provides due process for all interested parties. The Commission, consistent with its role as a fiduciary responsible for the preservation of the Commonwealth's natural resources and consistent with Pennsylvania Environmental Defense Foundation, acts with prudence, loyalty, and impartiality when it adheres to these regulations. In this manner, the Commission fulfills its responsibilities to protect the public's natural resources from depletion or degradation, while also allowing legitimate development that improves the lot of Pennsylvania's citizenry, as the Supreme Court recognized in Robertson Township versus Commonwealth. I agree with the ALJ's determination that the applicant, Mid-Atlantic Interstate Transmission, LLC, a successor in interest to Penelec, submitted substantial evidence to warrant the recommendation that the application be approved. I conclude that the evidentiary record, the process used to evaluate it, and the approval of this project is fully consistent with the Environmental Rights Amendment and the Supreme Court's opinion. Having addressed the main point of concern, the recommended decision requires additional modifications. First, the reference to PPL on page 86 of the RD is incorrect and should be replaced by applicant. Lastly, approval of the application should be conditioned on requiring MATE to comply with any and all permit requirements received from any agency or entity from which a permit is required in order to construct the project. This provision is similar to that required in our orders on PPL Susquehanna-Roseland 500 kV transmission line application. Therefore, I move that, 1, the recommended decision approving the application of Mid-Atlantic Transmission LLC as successor in interest to Pennsylvania Electric Company for approval to site, construct, and operate the proposed high-voltage transmission line referred to as the Bedford North Central West City 115 kV HV transmission line project, and the application to exercise the power of eminent domain to acquire the rights of way for the construction, operation, and maintenance of an electric transmission line and related facilities be adopted as as modified by this motion. 2, the applicant is to comply with any and all permit requirements received from any agency or entity from which a permit is required in order to site and construct the high voltage transmission line. 3, the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you.
You have heard the motion of Vice Chairman Place. Is there a second?
Second?
Second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, I do have discussion on the matter as amended that I want to put on the record in its entirety, and I just want to note the one paragraph to read. Many of the landowners that protested the application did so because of valid concerns regarding the manner in which the rights-of-way crossing their lands would be managed. Penelec has committed to keeping the lines of communication open with the affected landowners and to managing the rights-of-way in a manner that will not impair drinking water or crops. These commitments are an important part of why I am able to vote to approve the application, although I have previously voiced concerns over the vegetation management practices of another First Energy utility. I note that the Commission's review of the EDC's vegetation management practices, which was initiated this past August, has not yet been concluded, but I look forward to reviewing the information and recommendations of that collaborative working group. So on the matter as amended, is there any objection to taking the previous roll call? Hearing none, the motion passes 5-0.
It is recommended that the Commission adopt ALJ Salapa's initial decision in the matter involving the formal complaint of Jody Butts versus Columbia Gas of Pennsylvania, Inc.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
The next matter before the Commission is ALJ Vero's initial decision in the formal complaint proceeding of Cleotis v. Santee Jr. versus Pico Energy Company.
Is there a motion to call up the staff recommendation for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Under discussion, I do have a motion, so I will turn it over to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
Thank you. I will be reading my motion in its entirety. Before the Commission today is the complaint of Cleotis W. Santee Jr. alleging an inability to pay and seeking a payment arrangement. The complainant previously defaulted on 2 Commission-issued payment arrangements and one by PICO, the respondent, although the complainant subsequently retired those arrearages. The complainant's income when the last payment arrangement was established was in the amount of $7,028.27 per month for a household of 3 individuals. The record shows that the complainant's current income is $1,133 a month and 60 cents per week, minus a garnishment of $160.45 per week for child support. Section 1405D of the Public Utility Code authorizes the Commission to establish another payment arrangement if there has been a change of income of 20% or more for the complainants whose income exceeds 200% of the federal poverty level, or a decrease of 10% or more for the complainants whose income is 200% or less of the federal poverty level. As the record shows that the complainant's income has dropped more than 20%, under Section 1405D, the Commission can establish another payment arrangement. The matter should be remanded to the ALJ for the limited purpose of establishing a Commission-issued payment arrangement based on the record evidence of a change of income. Therefore, I move, 1, that the matter be remanded to the Office of Administrative Law Judge for the limited purpose of establishing a payment arrangement based on the record of the complainant's change of income under Section 1405D, and 2, that the OSA prepare an opinion and order consistent with this motion.
Thank you. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Any discussion?
Vice Chairman Place, I have a statement on this matter. I'd ask that my statement be entered in the record as though I read it in its entirety. Before the Commission is the initial decision that dismisses the formal complaint filed against PECO Energy Company. The complainant has defaulted on multiple Commission payment arrangements, as the Chairman has indicated, and requests yet another payment arrangement from the Commission. In denying the payment arrangement request, the initial decision follows our prior dissent on Caroline Matlin versus UGI Penn Natural Gas, Inc. In Matlin, the Commission did not exercise its authority to establish a second payment arrangement for the complainant who had experienced a change in income. The Commission cited to the complainant's prior inability to pay and reasoned that the requested payment arrangement would contain the same repayment terms as those upon the complainant had defaulted. I noted that the decision of whether to award a payment arrangement in this case is within the discretion of the Commission. Upon review, I don't believe we should exercise our discretion to grant a payment arrangement here. Although the complainant has experienced a change in income, the complainant's income level, a level 4, has not changed since the last Commission payment arrangement. Similar to Matlin, I don't see the point in granting another payment arrangement that would be on the same repayment terms and no more affordable in the arrangement upon the complainant's previously defaulted. Moreover, since 2009, the complainant has defaulted on multiple company and Commission payment arrangements. Meanwhile, as the date of the hearing, the complainant's outstanding account balance with PECO was $2278. I don't support granting another payment arrangement based upon a poor payment history, which is also the situation of Matlin. While the Commission is not bound to stare decisis, it must render a consistent opinion on either follow, distinguish, or overrule prior precedent. Here, the proposed motion does not address Matlin, yet alone explain why the Commission is not following the decision that appears to be on point with the current case. Thus, the proposed motion does not follow the Matlin precedent. It does not distinguish or expressly overrule it either. For these reasons, I agree with the initial decision to deny the complainant's request for another Commission payment arrangement and do not support the proposed motion. Thank you, Vice Chairman.
Okay. Any further discussion? Seeing none, all those in favor signify by saying aye.
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 Aye. Any opposed?
Opposed.
The motion carries 3-2, noting the dissent of Commissioner Coleman and Commissioner Kennard. Chairman, the gavel is yours.
On the matter as amended by the motion, any further discussion? Not. Is there any objection to taking the previous roll call? No, yes?
Yes.
Okay, take the previous roll call.
On
Or
3-2.
Okay. There's no objection to taking the previous roll call, noting the dissent of Commissioner Coleman and Commissioner Kennard. So the motion passes 3-2.
Continuing with the presentation of agenda items, the next matter before the Commission, and we do recommend the adoption of the ALJ HEAP's initial decision in the formal complaint proceeding involving Wayne O. Altman Jr. versus PECO Energy Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Under discussion, any discussion?
I have a statement. Right.
Vice Chairman Place.
Thank you. Madam Secretary, I request that my statement be entered into the record as I had read it in its entirety. Before the Commission for consideration is the initial decision of Administrative Law Judge Darlene Heap in the complaint of Wayne Altman Jr. regarding PECO Energy Company. The ID denies the complaint, which is a timely appeal of the Bureau of Consumer Services decision. Mr. Altman contends that PECO's new low-income program eviscerates PECO's assistance for low-income customers. Mr. Altman states that PECO moved from its previous customer assistance program, in which he qualified to participate, to a new cap fixed credit option. PECO indicates that this was completed in order to meet regulatory affordability guidelines, which the previous cap program did not. In the ID, ALJ Heap questions how Mr. Altman, under what was touted as a program improvement, now pays more for services with unchanged income. And at first, I did as well. Customer payment thresholds under the new plan are calculated by multiplying a customer's annual income by the appropriate affordability target, in this case, 16% of Mr. Altman's annual income. When FCO participating customers' annual bills fall under that threshold, as is the case with Mr. Altman, they do not receive a subsidized rate. While I understand the concern regarding a new higher bill, as were the bills of an estimated 40,000 additional customers, Mr. Altman's annual bills, even with the loss of the subsidy, remain below the affordability targets outlined in the Commission's CAP policy statements, and PECO's FCO plan does meet these current affordability guidelines. That said, universal service plans have significant impacts on vulnerable populations and require thorough Commission evaluation, including consideration of both intended and unintended consequences prior to approval of these revisions. The standards for and Commission evaluation of these plans moving forward is certainly ripe for discussion as part of the ongoing Universal Service Program review and energy affordability study. Thank you.
Thank you, Vice Chairman Place. Any further discussion?
Chairman, I also have a statement I'd ask to be entered into the record as I read it in its entirety. The complainant here objects to the change made to PECO's customer assistance program, which resulted in the complainant paying a non-discounted rate for electric service despite what is essentially unchanged income. I note that the complainant's bill is considered affordable under PECO's new cap design, which is why the complainant no longer receives the cap discount. I'd like to further note that the changes made to the PECO's cap are Commission approved, which means that PECO in this case was acting in accordance with the Commission's approved program. Thank you.
Thank you, Commissioner Coleman. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt both ALJ Jones's initial decision in the matter involving the formal complaint of Chantel Thomas versus Philadelphia Gas Works, as well as ALJ Myers' initial decision in the matter involving the formal complaint of Roseanne Ramo versus Metropolitan Edison Company.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
With that concluding the presentation of regular agenda items, we turn now to the Commission's carrying agenda. It is recommended on behalf of the Office of Special Assistance that the Commission adopt the recommendation in the proceeding involving the OCA versus Hidden Valley Utility Services LP and the petition for reconsideration there pending, as well as the recommendation pertaining to the petition for reconsideration in the matter involving the application of Suez Water Pennsylvania, Inc.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that does conclude the presentation of agenda items. Somebody left me out of the loop on that one.
Uh-oh.
Turning now to the supplemental carrying agenda, Madam Chairman and Commissioners, it is recommended that the Commission adopt the recommendation of the Bureau of Technical Utility Services involving the supplement number 2 to Tariff Telecommunications Relay Service PAPUC number 1, Hamilton Relay, Inc.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
With that, Madam Chairman and Commissioners, that concludes the presentation of public meeting agenda items.
Thank you very much. Before we adjourn, I didn't know if you were, okay. Okay, and I appreciate that. Before we adjourn, I would like to announce the Black History Month celebration that takes place every year, the multi-agency annual Black History Month celebration, which is always led by the Public Utility Commission. And we thank Cheryl Walker Davis and Rhonda Davison, who are leading that for our commission. The theme this year is the African Americans in Times of War. It will take place on Wednesday, February 28th at 12 noon at the Forum Building. And there's a pre-program entertainment commencing at 11:30 a.m. that day. There is also a reception the night before, which is Tuesday, February 27th, in this building, the Keystone Building in the atrium from 4:30 to 7:30 p.m. So we ask that all of you come out. The public is welcome to this event as well. And if there's nothing else, is there a motion to adjourn?
So moved.
Is there a second?
Second.
I see joint seconds. Motion by Commissioner Coleman, second by Commissioner Kennard. There's no discussion on this. Without objection, we are adjourned.